Okay, the second part of the paper is now focusing more on the cost court itself. And as you may be aware, an assessment or taxation of costs is usually taxed or entered into between parties. So you may have a party-party costs issue or cost dispute. That is where the losing party has to pay the winning party's costs, which doesn't necessarily involve you as a solicitor per se, as to your own costs. And of course there is the solicitor and client relationship, often described as a solicitor-client cost dispute, where there is a dispute or an assessment of costs as between you as a solicitor and your client, or the third party payer, as the case may be. So when you hear party-party costs as an expression or solicitor-client costs as an expression, that can mean the relationship between the parties in one sense. But if you look at the next box in the middle on the right, it can also mean the basis or the scope or the degree by which you may recover costs. Because party-party costs in a different sense means that the receiving party is entitled to all costs which are necessary or proper in the administration of justice in the conduct of the actual substantive matter. So party-party costs in a different sense can mean you only recover costs that were necessary or proper to be incurred. Solicitor-client costs in that same interpretation means all costs which are reasonable or reasonably incurred or of a reasonable amount. And then you have indemnity costs in effect, which means all costs which are those other than those which are unreasonable. So there's the expression which relates to the relationship between the parties, and a similar expression used in a slightly different context which relates to the nature of the costs by which you may recover. Just by way of example, if a client rings you up and says, "How's it all going?" and you say, "Oh, it's going well, we've done this, we've done that," on a solicitor-client basis you would be entitled to recover that particular item of attendance as a cost payable by your client to you, but it may not be a cost that the losing party has to pay the winning party, assuming your client's the winning party. So it's something that you may charge your client, but it may not be recovered from the losing party to ultimately go into the client's pocket. It's a question of whether it's necessary or reasonable. Okay, costs orders. Generally speaking, if an order is silent as to whether it's party-party or solicitor-client costs, if the court order just simply says defendant to pay the costs of the plaintiff, failing agreement to be taxed or whatever, but doesn't say party-party or solicitor-client or an indemnity basis or whatever, it means party-party. So if there's an order for costs in your favour without any particular expression, it means party-party costs. The receiving party or the winning party will be able to recover costs on a party-party or necessary and proper basis. If the court order actually stipulates a particular basis of costs, that the defendant must pay the costs of the plaintiff on a solicitor-client basis or on an indemnity basis, then obviously it's stipulated, and that is the basis upon which your client can recover costs, which would allow, in those situations, would allow a greater portion of the work to be recovered from the losing party. The same sort of thing would apply with terms of settlement. So if you are entering into terms of settlement where those terms refer to X amount to be paid to your client plus costs, just give some thought about what you are intending to mean by the plus costs portion of that document. Do you mean plus costs on a party-party basis, or plus costs on a solicitor-client basis, or plus costs on a full indemnity basis, or whatever? Obviously, a lot of settlement terms are all-in arrangements, so it wouldn't arise in that situation. But if you have a plus costs type terms of settlement, just be aware of the different degrees of costs that I've referred to. Okay, page 6. We're now looking at the process of a taxation of a bill. From the the hypothetical example of your aggrieved former client complaining about your costs, you will be requested, generally speaking, by the client to provide an itemised bill. The Act says that the client can knock on your door and seek an itemised bill within 30 days of having received a lump sum bill or even a request for payment. And a lot of solicitors have great joy in writing back to the client and saying, sorry, you're too late. Don't have to give you one. You're 15 days overdue. That will ultimately, of course, get you nowhere, because the Legal Profession Act has been designed by politicians, and politicians don't like to see that sort of thing happening. So in the Legal Profession Act, there is an opportunity for the client to knock on a different door, and that door is the cost court door, and the client can do so at any time up to 12 months after you've sent your lump sum bill or your demand for payment. And just to make sure that the client can even claw back bills that were rendered more than 12 months ago, there's even a provision in the LPA which enables them to do that if they can demonstrate to a judge of the court that it's just and fair to do so. So at the end of the day, if the client really works hard, all your bills can be dragged to the cost court no matter how old they are and whether paid or not. But generally speaking, the 12-month limit is about it. So don't be too precious when your door is knocked on a few days late and say, no, I'm not going to provide you with any itemised bill of costs, because the former client will just knock on the cost court door, and you will then have court expenses as well. Okay. If you cannot negotiate with a client some sort of agreed figure for your costs, then the client will invariably take out a summons for taxation. It's a very simple form. It's amazing how clients seem to know nothing about the law except summonses for taxation. So the summons will be issued. It will be issued with copies of all the bills that you've sent to the client, that is, the bills that the client wishes to challenge. And as I keep saying, it doesn't matter whether they've been paid or not. The matter will then appear in the call-over, in the cost court costs call-over, and orders will be made for you to file and serve an itemised bill for either all your work or a particular portion of your work, whatever it is that the client's basically unhappy with, subject to that 12-month limit I referred to before, which can be stretched in any event. You will then be put to the expense, which you cannot pass on to the client, of having an itemised bill drawn. You either do it yourself, not recommended, give it to a qualified firm of cost lawyers, recommended, and that will cost you a bit of money. They generally charge about 8 to 10% of what your legal costs come out at. That's usually excluding disbursements. So if you're having a bill that comes in at $100,000, then it's going to cost you about a fair bit of money, $8,000 or whatever, to have that bill drawn. You then file and serve it pursuant to the orders of the Costs Court, and the paying party, the former client, will have a particular period of time, probably 21 days or something like that, to file and serve a formal notice of objections. And the notice of objections will refer to each and every individual item in your itemised bill to which the client has taken objection. So there could be objection to items 1, 3, 7, 17, 24, all the way up to 586. So your 30-page itemised bill will be objected to on that basis, with expressions such as, or might I say unhelpful expressions such as excessive, not party-party, excessive, produce diary note, excessive. So that is what a notice of objections will look like, and then the matter will be set down for a taxation of that itemised bill, depending on the number of days it's going to take. It's probably going to be 2-3 months hence when the taxation actually takes place in the Costs Court. And assuming your 30-page bill has been thoroughly objected to, it could take anything from 1 to 5 days to tax, and that will be spread over about 3 months. So you will be going to the Costs Court, say on 2, 3, 4 occasions with your 20 boxes of files in the boot of your car to have your file or your bill taxed on that basis. If you are, I'll come to the nature of the process of taxation later, but if at the end of the taxation of your bill you discover that the $200,000 bill has been taxed and allowed at $75,000 and you are unhappy with that result, you can have the matter reconsidered or reviewed by the next person up in the chain at the Costs Court. So if you were before a cost registrar, it would then be reviewed by a judicial cost registrar. If you were before the judicial cost registrar, it would be reviewed by or reconsidered by the cost judge, and if you were before the cost judge, it would be reconsidered or reviewed by a Supreme Court judge. So you have that chain of hierarchy to review or reconsider, then review, etc. I might say if you get to the Supreme Court judge level, I don't know too many Supreme Court judges that like putting on their cost hat, so you won't get much sympathy, generally speaking, from a Supreme Court judge, because you are asking that Supreme Court judge to interfere with the discretion that was exercised by the cost judge of the Costs Court. And we all know how that goes. Okay. Getting the most out of your bill, that's the bottom right-hand slide on page 6. This really comes back to what I was talking about in relation to what occurs during a taxation of costs in the Costs Court. You will invariably, if you walked into the Costs Court now, you would see people sitting, not standing at the bar table. You would see boxes of files, papers everywhere, binders, counsel's briefs, invoices all over the place. There would be somebody sitting there representing you, and you might, for example, be there instructing someone like me. Of course, you may appear yourself if you wish, and going through your itemised bill item by excruciating item. And I can tell you there are circumstances where, for various reasons, there might be submissions as to whether a $37.40 item ought to be allowed, which can take 10-15 minutes. So if you've got a 30-page bill, or in one of my cases recently, a 199-page bill, you've got a rough idea of how long it's going to take. So getting the most out of your bill, as I've said here, the success of the taxation of your bill depends on the quality of your file. The only thing that will support your bill is your file. Don't come along to the cost court with affidavits trying to explain missing diary notes. Don't come along to the cost court with affidavits with your WIP ledger sheets exhibited. The cost court couldn't give a damn. It's the file that's going to support your bill. So any gap filling that you try and produce after complaint and after the summons for taxation is being taken out is not going to assist you. Every item in the bill that is to which an objection has been taken must be supported by the file. The minute the cost judge says to me, Mr. Lovell, please produce the diary note of that 2-hour conference, if I say I can't, it's taxed off. That's it, full stop. If I say, here it is, yes, I found it, Your Honour, and he says, please read it to me, please make sure you haven't denigrated the opposition. Please make sure you haven't explained in writing to give yourself a warm, fuzzy feeling what you think of the other side's solicitor, because that will be read out to the court with the other side's solicitor being there. And it finds no favour with the cost judge, because you'll look like a complete idiot when I'm reading out your swear words about the other person that you've been dealing with. As I've said later on in this paper, please make sure your diary note, which supports your claim for a 2-hour conference, does not comprise of 3 bullet points, some arrows and a drawing of a cloud. Because when I hand that up to the cost judge, because I can't read the small amount of handwriting that's on it, he won't be impressed by the cloud. And he will assume that this conference didn't take 2 hours. He may be satisfied there was a conference, but he might allow half an hour, a quarter of an hour, or in fact may tax it off if there had been an earlier conference with the same person 3 days earlier. In other words, why have another conference? So they're the sorts of things you've got to look at. Please make sure your diary notes, especially of conferences, mediations, or attending court instructing, have starting times, have finishing times, have reasonably comprehensive notes to support those claims that will appear in your itemised bill if you have to go that far. Okay, top of page 7, I've discussed the left-hand box. The right-hand box, counsel fees and disbursements. Counsel fees have to be justified just as much as your own costs. It is incumbent upon you during a taxation of costs to have copies of counsel's brief there, because invariably your itemised bill will claim a brief to counsel, it will claim your effort in photocopying 6,900 pages for counsel's benefit, most of probably which is not necessary anyway, but that's what will be in your bill. So you will need to produce the brief. You will need to produce the 6,900 pages you claimed you've copied. You will need to produce counsel's back sheet. You will need to produce counsel's tax invoice. You will need to produce counsel's fee memoranda if he or she has given a breakup of how their fees have been calculated. It can be a nightmare, and it's not your fault, it can be a nightmare if counsel has naively just charged a fee, reading advice, attending conference, blah, 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 going to court, $7,000 full stop, because there's no breakup. So the cost judge will try and attribute a notional breakup to what counsel should have done for the advice, what counsel how many hours the mediation went for, etc., 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 and then tax those fees down, because do not assume that counsel's fee rate will be accepted by the costs court. Counsel might be charging you and your client, let's say $440 an hour, but on a party-party basis, even before we get to that invoice, the cost judge might say, because of the nature of the substantive proceeding, he's only going to allow any counsel fees at $330 an hour. So straight away $110 an hour has come off anyway. And that's before we've reduced the number of hours from 75 hours worth of work to 35 hours worth of work. So when you do the multiple, you might find that there's been $15,000 worth of counsel fees taxed off the bill. That's counsel fees. And if you're the one that's liable to pay counsel, you might find that you're paying those fees out of your own pocket, the differential. That's on a solicitor-client basis, but the same thing applies on a party-party basis. So what I'm getting to is that a taxation of costs is not a logistically simple exercise. You'll see there at page 7, halfway down, items will be reduced, that's items claimed in the bill, will be reduced because of poor file records. An item is not necessarily taxed on or taxed off. It may be reduced for various reasons. As I said before, your 2-hour conference might be allowed at a half an hour. Your special letter might be seen as an ordinary letter. All these things have implications on the rate or the scale that applies. Your 6,900 pages that you copied for counsel might turn out, the cost judge might find that, why did you need to photocopy 6,900 pages? Why did you need to copy the entire constitution of the company when we were only talking about share forfeiture? Why did you need to put in an entire report about the safety of railway lines when it had nothing to do with the client's injury? So just be careful what it is that you are in fact giving counsel. Give some thought to whether you need to photocopy everything that comes across your desk and happily dump it in counsel's lap and think, well, it might be relevant, I'm not sure, because at the end of the day you may not recover that money on a party-party or even on a solicitor-client basis. The costs of the actual taxation, they are usually built into the bill. And if you see any itemised bill that's been properly drawn, you'll see that there's an estimate up near the end of the last page or the second last page of what the drawer of the bill believes the length of the duration of the taxation will be. So there will be an amount factored in. It could be an estimate of $800 for appearing on taxation, etc. But usually what the cost court allows is roughly between $330 to $425 an hour for the time spent in the actual taxation at court. That includes all your preparation. So if the matter runs for a couple of days, it could be 10 hours times 425. That will be the amount that will be allowed in the bill for your attendance at taxation, assuming you're the one recovering the costs or it's your client that's recovering the costs. Okay. There are situations where you may not receive the costs of the taxation, assuming it's your bill or your client's bill. And that is if there's a failure to comply with disclosure obligations, which I referred to in the first part of this talk. If it is a solicitor-client bill where you're trying to recover costs from your former client and the bill has been taxed from, let's say, $100,000 down to $75,000 in the ordinary manner, and one of the general objections that the former client has is poor disclosure or non-disclosure, you may cop another whack off the taxed amount, which could be 10, 15, 20%. That's the fingers chopped off whack. The highest I've known the whack to be is 30%. So you could have your bill tax from 100 down to 75, and then another 30% comes off for being a naughty boy or a naughty girl. So 30% is pretty high and very rare. one 30% illustration was reduced on appeal to 15%, but you don't want to be in that position anyway. So just give full and proper disclosure of cost estimates and so on. Obviously, the tactical impact of offers of compromise can come into play. So if the other side who's objecting to your bill or your former client has made an offer of compromise of a certain amount and you can't beat that, that can have an impact on the cost of the taxation, like as with any other court proceeding. And if it's a solicitor-client bill, this is back to you and your aggrieved client again. If your aggrieved client gets your bill reduced by 15% or more, and that's including disbursements, then you have to pay the cost of the taxation in any event. So and 15% is not much to get off a bill, especially if there's a lot of counsel fees and so on and so forth. So if you are having a bill drawn by a cost consultant on a solicitor-client basis, i.e. you and your former client, in my opinion, it's better to have the bill tightly drawn rather than as an ambit claim, because it's harder to get 15% off or more on that basis. So it's better to have it properly and tightly drawn. I don't want to suggest that they're ever improperly drawn, but some bills can be a bit ambit claimish, in fact, where the cost consultants try and pump the bill up to get as much out of the former client or the other side as possible. And it may be, sometimes that might succeed if the bill settles and you don't go to taxation. But if you're going to taxation looking like you should be bringing 20 boxes of files to support your bill and you've only got, 2 manila folders, the bill is going to be obviously pumped up and it'll be taxed down to an embarrassing amount, and you'll be paying the cost of the taxation. And even in that situation, you can be reported by the cost judge for misconduct and over-servicing, overcharging. So the final order, assuming there's a fully completed taxation, or even if you settle by consent, the final order will be that your former client or the losing party or whoever pays the costs of X, taxed and allowed at whatever the relevant amount is, and that is an enforceable order that you can enforce in the usual way. So my recommendation there in the last box of page 8 is maintain a well-ordered, thorough file for your own benefit. So I'll take any questions. We've got 5 minutes, Michael.
How does the cost court cope with the argument that you got it wrong or that you're negligent?
How does the cost court cope with the argument that you're negligent or got it wrong? Doesn't work. I can tell you that even if you thought you got it right and you weren't actually wrong, if you have provided you're talking about poor cost disclosure rather than no cost disclosure?
I'm talking about the case, the conduct of the case.
The substantive.
Being badly managed.
Well, they'll be taxed off. If you've badly managed the substantive proceeding,
Yes.
and it turned out a lot of work was perhaps, let's say, unnecessary or duplicated or whatever, that will definitely be taxed off.
And what about the
Absolutely.
circumstances where negligence is involved?
The solicitor's negligent.
Whether it be counsel or the solicitor.
Well, it'll still be taxed off, but whether you get reported for misconduct's another thing. But the cost court is fundamentally concerned about coming to a dollar figure. The cost court is not concerned so much about going behind that process, other than to report you to the Legal Services Commissioner or the LIV.
But it would have to listen to some sort of legal argument about whether something was wrong or something was
Absolutely.
Yes.
And the person representing you on your behalf or yourself will be making submissions that you didn't get it wrong. So, and sometimes if it's a critical issue, those submissions may be asked to be filed and served in writing. So, but it's essentially It's an assessment process to get to a dollar figure.
A professional account for an amount in excess of $25,000 is rendered to a client. The client seeks a detailed bill. That request is ignored and proceedings are issued by the solicitor. I take it from what you say, the client should refer that directly to the costs court. What happens to the recovery action that the solicitor's undertaken?
Any recovery action will immediately be stopped once it goes to the costs court because the LPA says so. And that's why I said earlier that it's preferable not to jump the gun and just issue a proceeding for unpaid costs in a court. In fact, I may not have made it clear, in fact, perhaps I overlooked it, but solicitors themselves can bring matters to the costs court. It's not just the clients.
I don't know if this is true or not. I've heard around the traps that if you've got a bill as a solicitor owing by the client, you have to wait, and then there are party costs. You've got to wait for the party costs to be determined before you can get your bill taxed. Is that the case?
Well, that all comes down to the indemnity principle. The indemnity principle means that you cannot make a profit on costs. In other words, if the solicitor-client costs are $100,000, you can't recover $105,000 on a party basis. That was an issue that was raised in the costs court about 18 months ago. The indemnity principle still applies, of course, but there's no hold-up as such to prevent the taxing of a solicitor-client bill of costs because the party bill hasn't yet been dealt with. But it's usually a general objection which doesn't go too far these days. And even on a party basis, even if the party costs haven't been dealt with, they would be constrained by what was recovered on a solicitor-client basis because of the indemnity principle.
The county court scale, a new one, and lack of certification of counsel now. We're finding it a problem at the costs court, and in particular with second counsel in litigated matters. It's a problem to the point where we think that counsel literally has to go to the taxation court now and sing for their supper.
That has occurred on the odd occasion. If counsel, where there's no certification for counsel, and that's now being dropped for various reasons, on a party basis, there is no requirement that the losing party must pay for the indulgence of the winning party. So if the winning party wants to have 3 QCs and 2 juniors, that's fine on a solicitor-client basis as long as it's been brought, those costs have been brought to the attention of the client by the client's solicitor. But on a party basis, there's no requirement that the losing party must pay for that indulgence. So it is commonly argued, in fact almost always argued, that if 2 or more counsel have been used by the winning party, that the losing party should not have to pay for the extra counsel. That is a matter which is simply determined by the cost judge or the cost registrar at the time of the taxation. Both parties will make submissions as to why 2 or more counsel should or should not have been used, and you stand or fall by that. And if you fall, then you've got the opportunity for a reconsideration or a review, but if you don't succeed, then it's your client that'll be out of pocket. So your client might have paid thousands of dollars in counsel fees but only recover, let's say, 50% of them as part of the overall party bill.
Peter, if the client has reached agreement either with counsel or with the solicitor as to a fixed fee for a defined scope of work, say for example counsel says that I'll do the appeal for $30,000, which will include 3 days of preparation and 2 days of hearing or something like that, and the client has agreed that that counsel should be briefed on that basis, can the client subsequently seek to have those counsel's fees assessed?
Yes, but it would be difficult for the client to succeed on that basis as long as there's been a clear disclosure, a clear acceptance in writing, not just phone calls and that sort of thing, and to be especially prudent to explain to the client that perhaps on a solicitor-client basis, or rather that the rates in any applicable scale are X, then you would be, in my opinion, home free. But if it just sort of happens, then you could have problems. Oh, last question? Is it? Okay, you're the last question.
I was just going to follow up from that question then. If you have a fixed fee agreement and you're then taken to the cost court by the other side because you've won, you'll still have to minus all of your works because they won't necessarily accept the fixed fee agreement that you entered into with your client.
Yeah, the mere fact that you've entered into a costs agreement or a fixed fee agreement, whether it's with yourself or the barristers, does not prevent assessment of those fees. They will be assessed or taxed and examined in the ordinary way, whether pursuant to an agreement, whether pursuant to scale, whether pursuant to the PRO, whether paid or not, doesn't matter. Thank you.
Peter, on behalf of everyone here, thank you very much for your very thorough presentation, and I thank everyone for attending. Just a reminder, there may have been one more question over here, I'm not sure. I'm sure Peter's free and available to have a chat outside. So thank you very much, and we look forward to seeing you again.